This presentation looks at some more information about the court structure, the way appeals happen in courts, and the idea of precedent. Precedent refers to a case that's happened before that a judge will use to influence their decision. For each court, they'll hear two levels of cases. So let's think about the district court, for example. We know they hear cases when the first time they come to court. That's called their original jurisdiction. So for example, the district court hears civil cases with a disputed amount between $150,000 and $750,000. As well as this original jurisdiction, they'll also hear appeals cases. For the district court, they hear appeals from the magistrate's court. And this is known as appellate jurisdiction and refers to the cases that they hear on appeal. Courts also have an important role in creating laws. There are two key sources of law. One is statute law. Statute law is the law that's made through acts of Parliament. So a bill goes into Parliament, it's heard by the politicians, voted on, and becomes an act of Parliament, becomes a law. For example, a law is the speed limit. Common law, though, is based on the decisions that judges make from issues that arise in their courts. Common law usually comes from civil law. Statute law comes from criminal law. And this introduces the Doctrine of Precedent. I'm sorry I've spelt doctrine wrong. Doctrine of Precedent is where a legal principle from a previous case is used to decide the same issue in a later case. So we think about the idea of a precedent in everyday life. It's something that's gone before. Well, these are cases that have gone before the current case, but are used to help decide it. Here we've got the Doctrine of Precedent with doctrine spelt correctly with an O. But the most important thing is that the lower courts are bound by decisions of higher courts in their hierarchy. These are known as binding precedents. So in a situation where the facts are the same, the decision has to be followed. For example, if a judge in the Supreme Court decides that liking a comment on Facebook is the equivalent of publishing it, which is very important in defamation trials, then judges in the district court must follow that ruling. They must follow that liking a Facebook page is the same as publishing. However, if there are factors that make the case that's being heard different from the precedent case, the court is not bound to follow the decision. Let's look at that Facebook example. Let's say in the case that's being heard currently, the person has no Facebook friends, so no one would have seen their like. Well, the judge might say, well, these are different facts, and they are going to distinguish the case from what has happened. So the case is said to have been distinguished. Decisions from overseas courts are not binding, but may help Australian courts make their decision. Judges have to provide a reason for their decisions, and they do this in two parts. The first is the ratio decidendi. That means the reason for the decision and the reasoning of the judge that is essential to the decision of the case. It becomes the binding precedent. The obiter dicta of the case means something said by the way, comments by the judge that are not critical to the decision. It is not a binding precedent. Probably the best way to think about this is to look at an example. Let's assume that a judge is ruling on a defamation case from social media. She might make the comments, the defendant has published material because she has liked it on Facebook and it is clear that many other people have seen the defamatory comment. She then goes on to say, however, if there was no evidence that anyone else had viewed the page and the defendant had removed their like of the page, this would not be considered publication. Breaking this down into ratio decidendi and obiter dicta, the main parts, the core part of her decision is that the defendant has published material because she's liked it on Facebook and it is clear many other people have seen the defamatory comments. That's the main part of the decision. The obiter dicta, the comments by the way, however, if there was no evidence that anyone else had viewed the page and the defendant had removed their like of the page, this would not be considered publication. The second part is not a binding precedent, but might be something that influences other judges looking at this situation in the future. This brings us back to the two areas of law that we talk about, common law and statute law. Common law is law that comes from court decisions, court-made law. Statute law, law that comes from acts of Parliament. Common law is generally associated with civil law, statute law with criminal law.